The End of Lawyers. Rethinking the Nature of Legal Services. Richard Susskind. 7. Access to Law and to Justice. Much of this book is devoted to the transformation of legal services that are delivered to a particular type of client, the substantial enterprise that is of sufficient scale and complexity to merit its own in-house legal department. But what about citizens, individuals, voters, consumers, regular people who have no special access today to lawyers and legal services? Forget for a while the general counsel with his or her team of perhaps hundreds of in-house lawyers. We may sympathize with their everyday workload and their growing legal risk burden. The challenge for these organizations is how best to allocate their often very considerable, but nonetheless finite legal resources. In contrast, the challenge for citizens who are not lawyers is often more daunting, because these lay people have no legal resources whatsoever and, unless they are uncommonly wealthy or sufficiently impecunious to qualify for state funding, they seldom have the wherewithal to engage lawyers. Franz Kafka, in a haunting short story, Before the Law, sets the scene for us. Before the law stands a gatekeeper. A man from the country comes to this gatekeeper and requests admittance into the law. But the gatekeeper says that he cannot grant him admittance right now. The man from the country had not expected such difficulties. After all, he thinks the law should be accessible to everyone at all times. It should indeed, but is it? To grasp the scale of the difficulties in England and Wales, consider various observations made by the formidably credentialed Public Legal Education and Support Pleas Task Force in the opening pages of an important report published in July 2. 1/3 of the population has experienced a civil justice problem, but many do nothing about it, often because they think wrongly that there is nothing they can do or that there is no local legal advice provider who might help. Around 1 million civil justice problems go unresolved every year. This is legal exclusion on a massive scale. The cost of managing legal problems is staggering. Ministry of Justice economists estimate that over a 3.5-year research period, unresolved law-related problems cost individuals and the public purse £1 billion. This alarming snapshot succinctly captures the problem of inaccess to justice in England and Wales, and this problem is the subject matter of the current chapter. 7. Redefining access to justice. It has been fashionable for some time now, amongst policymakers, law reformers, and commentators, to speak of increasing access to justice. While everyone seems to agree that access to justice is a fine thing, there is less unanimity over what this actually involves in practice. As a term of art, access to justice perhaps peaked in popularity in the mid-1990s, when Lord Woolf's seminal reports bore the phrase as their title. His emphasis was consistent with much theorizing and policy-making that has followed, on providing easier access to improved, cheaper, and fairer means of resolving legal disputes. While I emphatically welcome any initiatives that improve the accessibility and efficiency of our courts and of other methods of resolving disputes, and I remain a strong supporter of Lord Woolf's work, I do not think we should be satisfied that improving dispute resolution will be sufficient to achieve justice under the law. To be wholly or even largely focused on disputes in our pursuit of justice is, I submit, to miss much that we should expect of our legal systems. A richer analysis is needed. I could turn here, as I have done in the past, to a fairly philosophical approach to justice and look in turn at categories such as formal justice, substantive justice, and distributive justice, but I do not think these are the right tools for the job. Much as I enjoy legal theory, the discussion would run the risk of being too abstract. Instead, I prefer to draw a simple analogy from the world of healthcare. In law, as in medicine, I believe that prevention is better than cure. Most people would surely prefer to avoid legal problems altogether than to have them well resolved. As I say in relation to clients in Section 6, most people would surely prefer a fence at the top of the cliff rather than an ambulance at the bottom, no matter how swift or well-equipped. If this is so, then access to justice is as much about dispute avoidance as it is about dispute resolution. Just as lawyers are themselves able, because of their training and experience, to recognize and avoid legal pitfalls, in a just society, one in which legal insight is an evenly distributed resource, we should want non-lawyers to be similarly forewarned. In large part, this will involve introducing novel ways of putting legal insight at everyone's fingertips, and to an extent that has not been possible in the past. This readier, cheaper, and more widespread access to legal guidance should give rise to a more just society in the same way that immunization leads to a healthier community. Another effect is also likely. More widespread understanding of the law and access to legal remedies may deter unscrupulous individuals, such as some landlords, from pursuing unlawful or exploitative courses of action. In the past, they may have behaved as they wished regardless of the law, secure in the knowledge that those to whom they were causing suffering were deterred from taking action precisely because of the complexity or inaccessibility of the law and the courts. The medical analogy also helps identify a third sense of access to justice. I am thinking here of relatively recent work on health promotion. We are advised today to exercise aerobically for at least minutes, 3 times a week, not just because this will reduce our chances of, for example, coronary heart disease, but because it will make us feel a whole lot better. The idea is not only to prevent ill health, but to promote our physical and mental well-being. Similarly, the law can also provide us with ways in which we can improve our general well-being, and not simply by helping to resolve or avoid problems. Instead, there are many benefits, improvements, and advantages that the law can confer, even when there is no perceived problem or difficulty. And yet, many people are lamentably unaware of the full range of facilities available today, from welfare benefits through tax planning to making a will. In contrast, I look forward to the day when we will be committed to legal health promotion underpinned by community legal services that are akin perhaps to community medicine programs. Providing access to justice in this third sense will mean offering access to the opportunities that the law creates. This underlies one of the themes of the future of law, that in legal systems of tomorrow, the law will come to be seen as empowering and not simply restrictive. To summarize this line of argument so far, when I speak of improving access to justice, I mean more than providing access to speedier, cheaper, and less combative mechanisms for resolving disputes. I am also referring to the introduction of techniques that help all members of society to avoid disputes in the first place, and further, to have greater insight into the benefits that the law can confer. To translate this aspiration into reality, however, we must go further than simply rescoping the term access to justice. We need to assess more systematically than we have been inclined to in the past the facilities and techniques that will help to bring about this extended access to justice. My starting point here is a model that I developed some years ago, the client service chain. A simple variant of this is presented in Figure 7. This model proposes that the activity of obtaining legal guidance can be represented along a simple life cycle made up of three basic processes. The first is recognition, which is the process by which citizens or clients recognize, in respect of their particular circumstances, that they would benefit from legal guidance. Second is selection, the process by which citizens or clients select the particular source of legal guidance to help them in their given circumstances. And the third is service, the process by which legal guidance is received. Each of these elements raises access to justice issues. The first, the process of recognition, is characterized today by what I call the blatant trigger. By this, I mean that the client is urged to seek legal guidance on the occurrence of some event, or in a set of circumstances that quite patently call for formal legal input. It is at the client's instigation, therefore, that the legal machine rolls into action. It is in this context, in the future of law, that I characterize traditional legal service as being reactive in nature. The blatant trigger, perhaps the receipt of a claim, the death of a relative, the commencement of negotiations on some major deal, or some similar such occurrence which clearly demands proper legal help, leads a client of today to instruct his or her lawyer. In other words, the lawyer reacts to the client's call for help. All too often, and unhelpfully, the lawyer responds in the first instance, accompanied by an irritating intake of breath, by saying that it would have been better if the client had come along earlier. This is the basis of what I have called the paradox of traditional reactive legal service. You need to know rather a lot about the law to recognize not just that you need legal help, but when best to seek such counsel. The net result is that clients are often disadvantaged, either because they look for legal guidance too late or because they miss altogether an opportunity to assert their entitlements. In a society in which there is genuine access to justice, there should be facilities in place to help non-lawyers to recognize, at the most propitious time, that the law impacts on them whether to empower or inhibit them. Fig. 7, the client service chain. As for the selection process, currently this remains rather hit and miss. Traditionally, a variety of factors have brought a lawyer's capability to the attention of potential clients, including advertising, local physical presence, recommendations, and general reputation. Sometimes non-lawyers will instruct a law firm, not with any knowledge that the legal business has relevant skills, but simply in the comfort that that same firm has undertaken legal work satisfactorily for them in the past. Even for the most sophisticated users of legal service, like the general counsel in charge of a substantial in-house legal department, the full range of law firms in practice gives rise to a bewildering selection process, given the diversity, complexity, and sheer numbers of apparently qualified legal providers. If we are sensibly to claim that our legal system affords access to justice, we must surely have processes in place that enable clients with no legal knowledge to find appropriately qualified lawyers who will offer a competitively priced legal service. And similar assistance will also soon be needed to help citizens to make sense of what may appear to be a bewildering array of online legal tools. What about the third element in today's client service chain? This is the service element. Today, the dominant means of imparting legal guidance is through the delivery of advice by lawyers, invariably reduced at some stage to writing, usually after face-to-face consultation, and normally invoiced on an hourly billing basis. More, the advice tendered is packaged for the direct consumption of one particular client. Rarely is it intended that that guidance should be reused by others, even the client themselves. If we are to increase access to justice, I submit that we must continually be exploring and introducing methods of legal service that are less costly, time-consuming, emotionally draining, and forbidding than the time-honored consultative advisory approach. Much that is said in Section 2 about the multi-sourcing of legal service can therefore be applied in the context of the citizen. Improving access to justice, therefore, will require much improved facilities in place to support clients, to recognize that they need or would benefit from guidance on dispute resolution, dispute avoidance, and legal health promotion, to help them to identify and select the most appropriate source of guidance under all three headings, and to ensure that a wide range of sources are indeed available. Improving access to justice on this more ambitious scale should also help us to liberate what I call the latent legal market. I'm alluding here to the innumerable situations in the domestic and working lives of all non-lawyers, in which they need and would benefit from legal guidance or earlier, more timely or empowering insight. But obtaining that legal input today seems to be too costly, excessively time-consuming, too cumbersome and convoluted, or just plain scary. I believe this market will be liberated by the availability of straightforward, no-nonsense online legal guidance systems and by other methods of sourcing legal service. They will not always replace conventional legal service, but they will provide affordable, easy access to legal guidance where this may have been unaffordable or impractical in the past. I have often been asked if my latent legal market is just a fancy term for the rather more earthy concept of unmet legal need. In a sense it is, in that they are two sides of the same coin. The underpinning fact here is that specialist legal help is needed today far more extensively than it can be offered and taken. From the point of view of society generally, this is well characterized as unmet legal need. Whereas from the lawyer's perspective, I regard this as a large untapped market, happily not an opportunity for exploitation or monopoly, but the chance to contribute at a fair rate of return to the grave problem of inaccess to justice. In law, as elsewhere, there seems to be a long tail of demand that has not been satisfied by the working practices of the past. 7. The building blocks of access to justice. With this analysis of access to justice to hand, we can now pin down the fundamental social challenge. The standard rendition of the problem proceeds along these lines, insofar as lawyers and sometimes the courts are involved. Solving legal problems and resolving disputes is affordable, in practice, only to the very rich or those who are eligible for some kind of state support. And the standard question that follows this bleak peroration runs something like this: how can we extend the availability of legal services so they are not confined to the poles of the financial spectrum? If my thesis of the previous section is accepted, this standard analysis understates the dilemma. The broader reality is that it is not just legal problem-solving and dispute resolution that require legal experience and knowledge that most citizens do not possess and cannot afford. Also beyond their ken and wallet are problem recognition, advisor selection, dispute avoidance, and legal health promotion. How on earth, at affordable cost, can we deliver this full range of legal tools and facilities and, in turn, access to justice? The options are limited. One possibility is to increase state funding of legal services. In most jurisdictions with which I am familiar, this looks very unlikely to happen, not least because justice, especially civil justice, tends to compete poorly with other demands on the public purse, most notably health, defense, education, and transport. We can argue with conviction, along with Lord Newberger, the law lord, that civil justice and the preservation of civil society, through enforceable contracts and property rights, for example, are the foundations upon which nation-states are built, and so should have a first call on public funding. I fear, however, and for reasons too numerous to itemize, that this line of thought does not resonate with today's policymakers and politicians. I have seen inside the workings of government for long enough now to hazard, instead, that there will be less rather than more funding made available to promote access to justice in the foreseeable future. This situation is in many ways similar to that facing in-house lawyers who are strapped for resources. Like general counsel, citizens who hanker after greater access to justice want more for less. If this is so, they should pursue the two basic strategies that I put forward in Section 5, the efficiency strategy and the collaboration strategy. Using the former, we can cut the cost of providing access to justice. For example, radical efficiency gains and cost savings should be achieved within law firms through standardization and computerization, while various other sources of legal counsel can also be brought into play, often using different channels for delivery, such as call centers and video calling. Or following the latter strategy, we can share the costs of providing access to justice amongst the participants involved, for example through legal open sourcing or closed legal communities that enable the burden to be shared across large communities of those in legal need. See Sections 4 and 4. In seeking to meet the grave social and economic challenge of providing greater access to justice at less cost to the public purse and the citizen, I therefore hope we can draw on the thinking and practical suggestions made elsewhere in this book in relation to commercial clients. Even if the legal problems of the citizen are quite different from those of the in-house lawyer, the more general theme, that of providing more for less, is remarkably similar. In the pages that follow then, I point once again to the wide range of disruptive legal technologies, as discussed in Chapter and Section 6. As ever, while these systems may be unattractive and threatening to conventional legal businesses, the changes they bring will often deliver direct benefits, especially cost savings and quality improvements to the client. And once again, those legal businesses that choose to embrace disruptive technologies ahead of later adopters may in so doing secure some kind of advantage in the marketplace. More generally, though, the challenge of increasing access to justice can be met, at least in part, by using the techniques of decomposing and multi-sourcing, as introduced in Section 2. If we are serious about reducing the costs of legal service, we should be decomposing legal work that has been, or should be undertaken, for citizens into constituent tasks and allocating these to the least costly sources of service that we can find, so long as this multi-sourcing and mass customization Section 2 does not fail to deliver the requisite quality of guidance that the non-lawyer needs. We can look at the future in another way, in terms of the evolutionary path that I lay out in Section 2. On this model, I am anticipating a move away from an arbitrary few citizens receiving traditional bespoke legal advice to many more members of society benefiting from the efficiencies and savings that can be achieved across the justice system, along my evolutionary path, through standardization and computerization. In a more efficient justice system, when there is mass customization, the unit cost of individual bits of legal service will reduce, and in turn, there should be greater access to legal services and to justice. We will get more punch from our pound. In practice, assuming that there is no radical change up or down to the level of public funding made available for legal services, and in parallel with the improvements to the court system that I recommend in Section 6. In 6, I propose that improved access to justice can be achieved in the future by a combination of 6 building blocks as follows. First of all, citizens themselves must be appropriately empowered, so that they can take care of some legal affairs on their own and work more productively with those who advise them, if guidance from others is needed. The second building block is a streamlined legal profession with law firms that multi-source, embrace technology, progress towards commoditization, and offer pro bono services that dovetail sensibly with other sources of legal guidance. The third is a healthy third sector, recognizing that many citizens who are in need of legal assistance want a kind, empathetic ear with only a light sprinkling of legal expertise. Fourth, a new wave of imaginative, entrepreneurial, and market-driven alternative providers of legal service are vital to the mix, bringing new ways of making state funding go further, keeping law firms on their toes, and delivering service in a manner with which consumers are comfortable. Penultimately, to support all who need to wade their way through the law, statutory source materials and case law should be easily accessible and digestible through no cost to users' legal information systems. In turn and finally, there must be in place and in practice an enlightened set of government policies relating to the availability of public sector information. In the remainder of this chapter, I look at each of the 6 in turn. 7. The empowered citizen. In economic terms, lawyers are a scarce resource, and they are a resource that is distributed unevenly across society. When most private citizens seek legal advice, they cannot afford to retain lawyers for anything but a very few consultations, and those who wish to resolve disputes are often deterred by the prohibitive cost of litigation. However, and I hope I can take all readers with me on this fundamental point, even if lawyers are a scarce resource, we cannot allow justice to be similarly pigeonholed. The social challenge here, one of forbidding complexity, is to provide those who lack the funds to engage lawyers in the traditional manner with alternative and complementary sources of legal help. Part of the answer is to blend the work of new-look law firms with contributions from the third sector and from alternative providers. But even this more imaginative sourcing will not be enough. In the end, citizens themselves will need to bear much of the burden. In prosaic terms, we are in the realms of DIY law and legal self-service. In the lexicon of the day, we need to empower citizens to sort out some of their own legal issues. How do we actually go about empowering citizens? I suggest there are 2 principal techniques. The first is what I call legal awareness raising, and the second is information technology, IT, in various shapes and forms. With regard to awareness raising, I draw a distinction between this notion and the apparently broader idea of public legal education, PLE, as defined, for example, by the PLEAS task force. My ambition for legal awareness raising is to enable citizens to be sufficiently familiar with the law and the legal system to recognize when they need some kind of legal help. I take the task force to be more ambitious. As I interpret their view of PLE, this seems to extend to educating citizens so that they actually know and understand various substantive legal issues. When I speak of legal awareness, I am reminded of the knack that most lawyers have, of sensing when certain circumstances give rise to a legal concern, even if they are not really familiar with the particular area of law. Just as alarm bells ring in their ears, I want citizens to have sufficient awareness of the law to have the same inbuilt early warning systems. I do not think we need to take the further educational step of teaching citizens in any depth about their civil rights and duties. All that we need do is equip them with knowledge of where and how to look up the law and so determine these entitlements and obligations. In the same spirit, this is what many professors say to their students about undergraduate legal studies, that the object is not to learn the law but to know where and how to find it. Likewise with citizens. They should be coached so that they know when they need legal assistance and what resources are available. In terms of my client service chain, see Section 7, I am therefore inclined to restrict awareness raising to the recognition element, so that citizens can tell when legal guidance will help them to solve a problem, avoid a difficulty, or even promote their legal health. I see a much more modest role for awareness raising in respect of the selection and service components, where guidance from human advisors or smart systems is more practicable than educating citizens. As for channels for the delivery of legal awareness raising, there are many options. Public bodies, law firms, third sector bodies, and others can produce handy leaflets, magazines, information packs, and websites. Newspaper articles and TV coverage should also work well. And here, too, is a wonderful opportunity to unleash e-learning in earnest. See Section 4. There can be little doubt that a webcast, or even a simple voice-only podcast, presented by a friendly and articulate person in ordinary language and not legal jargon, will be easier for many citizens to assimilate than inviting them to plow through text. I turn now to the ways in which it, more widely, can complement legal awareness raising. This is the second technique for empowering the citizen. In the past, most discussions of increasing access to justice through advanced IT have focused on online self-help facilities that offer guidance on questions of substantive law. In terms of my client service chain, the focus has therefore been on the service component. This has been appropriate, but we can and should go further and give thought to the ways in which citizens can be supported by it in recognizing when legal help would be beneficial, and in selecting the most appropriate sources of legal help for their purposes, although in practice, these two processes often blend into one. So what kinds of systems might make it fairly easy for citizens to recognize that legal assistance would be beneficial? On analysis, it emerges that there are two problems of recognition. The first is where citizens already sense that legal input of some sort would be useful, but need help in understanding and classifying their situation, so that they then know what kind of help or solution to pursue. This sense that they have might be the result of some successful legal awareness raising, or it may be triggered by some self-evidently legally charged event, an aggressive letter from a solicitor perhaps. In either case, are there online systems that might offer the navigational help they require? I think we should again borrow and computerize a technique that seems to work well in healthcare. The technique is known as triage. When resources are scarce and all patients cannot be treated at once, this is a process for assessing and prioritizing needs according to the seriousness of patients' conditions. The idea is to optimize the deployment of available professionals and facilities so that more patients can be seen than would be on a first-come, first-served approach. Vitally, top clinicians only see severe or complex cases, and the most straightforward conditions are dealt with by the most junior medics or nurses. By analogy, I envisage a form of legal triage, and I discuss this in more detail in Section 7. For now, though, I propose the idea of online legal triage. This would provide citizens with guidance on the type of legal help they require, a law firm or third sector provider, for example. One version of this could be entirely IT-based, perhaps an interactive diagnostic expert system that would ask a series of questions and then make recommendations. The system may confirm that it would be wise to secure legal guidance of a particular kind, or it may suggest that their problem is not really a legal one. Another online tool could be a facility that invited citizens to explain their circumstances through emails, and these messages could be assessed by human lawyers or advice workers who, again, might confirm or not that legal guidance would be appropriate or beneficial. An impressive variant of this approach is found in Law Help, a US-based system that allows citizens to interact with specialists through a type of instant messaging, a real-time chat facility. The specialists do not answer the questions put to them but point the user to promising online resources. This to some extent combines both the recognition and selection elements of the client service chain. I now see that I had a type of online legal triage lurking in my head when I was an advisor in and to Sir Andrew Leggett on his review of tribunals. I suggested then that there was a pressing need for some kind of facility which would help citizens and organizations to identify the most appropriate forums for the resolution of their differences and difficulties. Again, I envisaged a web-based expert diagnostic system. A citizen would answer a series of online questions about his or her grievance, and in turn, the system would identify the court, tribunal, ombudsman, complaints procedure, or other method of resolution that seemed best suited to the dilemma at hand. This idea remains unimplemented, but I still like it, because I do know that many citizens are bamboozled by the wide range of options that seem to confront them when they seek to solve a problem through official channels. The second problem of recognition is more challenging. This is when citizens have no sense at all that the law bears directly on their circumstances. More accurately, it is a problem of non-recognition. This most commonly prevails when there is no blatant trigger, such as personal injury or a pugnacious letter from a solicitor, to alert the citizen and set alarm bells ringing. Often, the consequence is an opportunity lost. Without legal insight, a chance is missed, perhaps to take steps to avoid some impending legal problem or to take advantage of some benefit that the law would confer. Aside from legal awareness raising, whose focal point I argue is in widening recognition, how can it help? Drawing on my arguments of Section 4, this is surely a job for what I call embedded legal knowledge. There is scope, for example, for the more widespread introduction of personalized alerting, which will result in citizens being notified of new legal developments that affect their lives. Once an individual builds up a profile of his or her activities, or joins communities, whether open or closed, of people with shared interests, then distilled, relevant, and tailored briefings will be sent to them. In this way, citizens may be urged to be proactive. Personalized alerting will function like a lawyer who calls up periodically and suggests, because a client works in a given trade or business, then he or she should take a particular precaution or might like to take advantage of some opportunity. I say more about this in Section 7. Document Assembly Technology Section 4 can also help here in enabling lay people to create robust legal documents that will protect them in the future. Consider Risk Remedy from NatWest. This online service helps lay people to prepare legal documents, for example employment contracts, without, as it is claimed, resorting to expensive solicitors. What about the selection element of the client service chain? If we assume that a citizen has recognized that he or she would benefit from legal guidance, what kinds of systems might guide that person, for example, to the most appropriate lawyer or advice worker or online service in the circumstances? I have high hopes here for the emergence of the electronic legal marketplace that I discuss in Section 4. Using techniques with which citizens will be familiar from their other online activities, I predict there will soon be many websites that will actually help clients to identify suitable lawyers or other sources of help, much as systems can help patients to find appropriate doctors, and they will help clients to secure services at highly competitive prices. Such systems already exist, and I provide examples of them in Section 4. In due course, citizens will even benefit from online legal auctions akin to eBay. These sites will drive prices down, and facilities will also be available to offer better insight into what legal fees to expect and to hear from others about their legal experiences. This will give the comfort of knowing that the lawyers they choose have given satisfaction to others. Still on the question of selection, citizens should also be able to consult the web when contemplating whether to pursue formal action in the courts. Online help, perhaps using e-learning techniques, on how to pursue or defend a claim should be readily available in punchy and graphical form. This could be designed for those who are already involved in a dispute as well as those contemplating action. A basic system could be provided by the court service, but feedback, observations, insights, and tips from court users could also be encouraged, thereby helping citizens make informed decisions about how or whether to proceed. Turning now to the service element of the client service chain, I also expect that citizens will increasingly turn to the web as their first port of call whenever they have a legal problem, or they have recognized a risk that needs to be managed, or they are pursuing some way to enhance their legal health, exploring their eligibility for some tax rebate, for example. Whether through primitive FAQs, frequently asked questions, or artificial intelligence-based diagnostic expert systems, many legal issues on the minds of citizens will be handled through consultation with some online legal service. No longer will it be assumed that the citizen always needs to consult a qualified lawyer or third sector advisor. Once again, my Disruptive Legal Technologies, Chapter 4, will come into play. Automatic document assembly systems will enable citizens to generate fixed or no cost, reliable and robust letters and agreements simply by responding to online questionnaires. Online legal services will actually provide guidance and answers to legal problems. Online communities will burgeon, where useful materials are made available in open source spirit and built up using wiki techniques. Citizens will record their legal experiences on blogs for others to examine, and they will pose and answer questions on discussion forums. That citizens may come to be guided by unofficial sources rather than authoritative law itself raises interesting issues about the nature of law. This guidance itself may come to be regarded by many as the law itself and not just a representation of it. This would be a powerful illustration of what the legal sociologist Eugen Ehrlich once called the living law, the law which actually reflects and conditions behavior in society. This new genre of legal help may also introduce a further dimension to what has been called the delegalization of law. In any event, these new facilities will not be organized under conventional legal headings, such as contract, tort, or agency, nor will they be subdivided into legislation and case law. Instead, the resources will be presented and categorized as life events that citizens will immediately recognize as matching their position or predicament. Beneath self-evident headings such as "I have been fired," "I want to start my own business," "I want to write a will," "I am in dispute with my landlord," will lie the resources that I describe. This idea of organizing online legal information in terms that non-lawyers will immediately grasp is well illustrated by a fairly simple website that helps motorists who fall foul of the increasingly draconian road traffic laws in the UK. The site provides a wealth of information on road traffic offenses, including guidance on speed cameras, motor accidents, mobile phone usage, seatbelts, and car insurance. A handy table of driving offenses is presented, indicating for each the likely penalties and whether or not disqualification or fixed penalty options are possible. A free road reckoner is available to answer that age-old query, what will I get? Finally, in relation to online facilities for citizens that may complement or displace conventional service, there is online dispute resolution, as I describe in Section 6. Systems such as Money Claim Online allow non-lawyers to prepare their own claims and to pursue legal action without directly involving anyone from the legal profession. These various suggestions for securing legal service and guidance online will no doubt be frowned upon by technophobes and legal reactionaries alike. In concluding my discussion about the empowerment of citizens, I want to address some likely objections. One important concern is that not all websites with legal content will be accurate or reliable. This clearly is a legitimate worry. Part of the challenge here will be to raise awareness amongst citizens about which online legal brands are robust and perhaps officially endorsed. I see this as an important role for government. Once again, there is an interesting analogy to be found in medicine. Some doctors have major misgivings about the volumes of medical information that are now available online. They agitate about the accuracy of the guidance offered and harbor the more general fear that, when it comes to medical health, a little knowledge can be a dangerous, if not fatal, thing. On the other hand, other doctors welcome online medical resources, less perhaps for their accuracy but more for the way in which they encourage patients, as is said, to take greater responsibility for their own illnesses. On this argument, patients come to their doctors, if not fully informed, then certainly more engaged than has been possible in the past. Similarly, in law, even if the provision of online legal service, whatever its manifestation, may not always definitively resolve or dispose of a legal issue, it may nevertheless engender a greater willingness amongst deserving citizens to seek further help where in the past they might have felt deterred. Another understandable concern that I expect to be voiced is that online service is rarely as good as the real thing. There is no substitute, it will be said, for seeing an experienced lawyer face-to-face. In many but not all circumstances, I agree. I return to this question in the following section. For now, though, I want to stress a harsh reality. Given the extent to which legal expertise is a scarce resource, one-to-one consultative advisory guidance is a service we cannot always resource or afford. So I respond, as I have for many years, by saying that the judicious use of it can sometimes help to provide legal guidance to individuals who would otherwise go without any counsel whatsoever. And those who reject IT-based services because, in an ideal world, human service of a higher standard would be available, are allowing, as Voltaire would have said, the best to be the enemy of the good. A further well-intentioned objection to all of this technology, I know, is that some citizens do not have access to the internet. This problem is known in the trade as the digital divide. This refers to a new partition in society between those who have access to the internet and those who do not. In fact, around 2/3 of households in the UK have internet access. My guess is that this figure will rise in the next few years, but it may well plateau at around 3/4. Whatever the fraction, the percentage is significant, although not nearly as significant, I cannot resist saying, as the number of homes whose information-seeking habits have been transformed by the internet. To be blunt, I think that the impact of the digital divide on access to justice can be overstated, and sometimes disingenuously so. In the first instance, when we look at the research more closely, we find relatively lower levels of usage amongst the elderly and the less well-off. The cynical might say we should not be too worried from an access to justice perspective about the less well-off not having internet access, because many of those who are least likely to afford technology will, by definition, be eligible for legal aid. Whether or not this is convincing, it is unquestionably the case that some internet-deprived citizens can be described as secondary or proxy users, which means that they do not themselves sit down and put finger to keyboard, but have someone else sit in the driving seat on their behalf. They can be said to be indirect beneficiaries of the legal resources on the web. Many elderly people fall into this category. They delegate web browsing to their children and grandchildren. Another class of indirect beneficiary, of course, are citizens who are guided by advisors, not least in third sector, who themselves are productive internet users. All of which is to say that the number of people who are actually disadvantaged by being non-users is appreciably less than at first blush. In any event, to rehearse another running theme of my work since the 1990s, even if we concede that some individuals do not have direct or indirect access to technology, I maintain that a higher percentage of members of our society have access to the internet today than have access to justice. In 2, I wrote, with some regret, I would bet that more people of all social classes will have access to the internet, and so to the law on my theory in 5 years' time than have access to justice today. Sadly, I think I was right. 7. Streamlined law firms with all kinds of internet-based services available to the citizen. Where does that leave lawyers? To pinpoint the role of lawyers and law firms in the new world of consumer legal services, we should return to first principles. In the first chapter of this book, I challenge lawyers to introspect and ask themselves honestly what parts of their current workload might be undertaken differently, more quickly, cheaply, efficiently, or to a higher quality, using different methods of working. I say that the market is increasingly unlikely to tolerate costly lawyers for jobs that can equally or better be undertaken by less expensive workers or through smart systems and processes. This same thinking should be brought to bear in the context of access to justice for the individual citizen. We should expect, following the arguments of Section 3, that some tasks, for example those requiring deep expertise or interpersonal communication, will still require the traditional lawyer. But firms that are keen to survive must nevertheless be willing to decompose and multi-source across their practices in the manner laid out in Section 2. Far more internal delegation to more junior lawyers will be needed, as will delawyering, that is, passing work to paralegals and legal executives or intelligent lay people, where to use legally qualified individuals would be to over-egg the pudding. Outsourcing, subcontracting, relocating, and the various other means of sourcing that I identify should also be deployed. In this new world, if law firms wish to remain center stage in the production of legal service, they will also need to develop their project management skills so that they can be responsible for managing a multi-source service and delivering it to clients, see Section 2. At the same time, computerization should always at least be an option for consideration. This will involve systematizing, packaging, or commoditizing, as I explain these terms in Chapter 2, and will inevitably require some investment in those technologies that I dub disruptive, see Chapter 4. For instance, the far greater use of automated document assembly, Section 4, and workflow systems, Section 4, should become standard practice amongst firms that aspire to the efficient disposal of relatively routine work. Another example, the advent of social networking, instant messaging, video conferencing, and telepresence will change the way that lawyers and citizens communicate with one another, removing much of the unnecessary noise and friction that characterizes conventional legal service and gives rise to unnecessary expense, see Section 4. And with the emergence of electronic markets, where legal work can be auctioned, details about reputation and performance can be recorded and maintained, and where directories of lawyers are available, citizens will be able to secure legal services at far lower and transparent cost than in the past, see Section 4. In other words, law firms that serve citizens will be as deeply affected by the arguments of this book as their commercial cousins. And the tools and techniques that I have identified for larger firms can and should similarly be put to service in support of smaller practices. Whether law firms can survive in this market will depend on the extent to which traditional lawyers are genuinely needed, when they are frankly and dispassionately compared with their emerging competition in the broadest sense, which includes a healthy third sector, entrepreneurial alternative providers, online self-help, and the various other sources of legal guidance that are and will become commonplace. Survival will also rest to some degree, therefore, on whether law firms can reinvent themselves, embrace new skills, and so provide newly competitive legal services. My expectation is that law firms will adapt, but within limits. I predict that they will be most active in relation to the service component rather than recognition and selection elements of my client service chain, see Section 7. In the service itself, I suspect, will be largely dispute resolution and problem solving rather than dispute avoidance or legal health promotion. Within these limits, lawyers who advise citizens will probably come to think that they have two classes of new competitor: lay people who are armed with packaged or commoditized self-help online legal tools, or less costly legal or quasi-legal workers supported by smart systems, and often operating from low-cost areas. However, following the arguments of Section 4, there is another threat, if not a distinct threat, then a development that will bolster the two threats already in play. I have in mind legal open sourcing. Just as citizens can go online today and obtain punchy and effective help on how to fix their computers and on medical matters, then so too a rich body of open-source legal material, standard documents, commentaries, personal experiences, and more will appear on the web. These will radically enhance the self-service experience and greatly assist the less costly and quasi-legal workers. As I suggest a little later in this section, lawyers could have a role in contributing to this body of knowledge. More generally, entrepreneurial law firms will not see threats in all of these developments. Some will find promise in business in the latent legal market, for example. Some lawyers will be quick to respond to much that is said above in words of the following sort. Most clients, when they are in life-changing or career-threatening circumstances, will want to sit face-to-face with a proper lawyer and will not want to go online or speak to a paralegal. This is an important challenge that must be addressed squarely. I start with a concession. I have little doubt that some people today, as a matter of fact, do indeed prefer to consult a lawyer when a major personal or work-related issue arises. That said, we also know from the research of which, and others, that satisfaction levels with lawyers are not compellingly high and many are sympathetic to alternative providers. In any event, aside from what is the case today, I am more concerned with how we ought to configure and provide legal services in the future. I am focusing here incidentally in terms of the client service chain section 7, on the selection and service elements. I think it helpful now to introduce a new concept, the idea of legal triage. For a layperson to visit a lawyer directly whenever he or she deems it appropriate may be as wrong-headed as a patient with a mildly grazed knee going directly to an accident and emergency consultant without being reviewed by a nurse. A sensible first step for clients and patients alike is an initial appraisal of their circumstances to determine the most sensible course of action. In law, I call this legal triage. Whether by human or online triage, see Section 7, the citizen's situation can be assessed and the best type and source of guidance can be determined. This assessment need not involve a lawyer. It might be the province of a suitably trained paralegal. The client might be directed to a lawyer in the first instance, but on many occasions their situation and profile may lead to a different referral, to an advice worker, to a website, or perhaps to an alternative provider. This form of human legal triage can straddle the recognition and the selection elements of the client service chain. Lawyers should only be engaged when their distinctive skills and expertise are needed. And here is the crux. The lawyer might feel, because of the gravity of the circumstances, that he or she is the person for the job. Legal triage may suggest otherwise. A marriage counselor or a social psychologist, for example, might be a better first port of call. And even if a lawyer is thought to be necessary in the first instance, this does not mean that this advisor should be personally engaged throughout the life cycle of the client's episode. Triage may suggest, for instance, an initial consultation with a lawyer, but followed thereafter by a supervised multi-source service. Looking some years into the future and following what I say in Section 3, I do not think we can, in any event, simply assume that our children will find it as natural as their parents to meet face-to-face with those who advise them. Mere assertion today by lawyers that clients like to look them in the eyes will not bind future generations. The net result of all of this is that, in years to come, legal triage, multisourcing, and it will combine to diminish the direct involvement of lawyers in the legal affairs of citizens. In fact, there are many areas of legal service delivery, for example social welfare law, where lawyers are already much less involved than they were in the past. When lawyers are engaged in the future, they will bring to bear deep expertise or the specific interpersonal skills that are called for, and this service will be underpinned by newly fashioned and more sustainable business models. For those law firms that continue to trade, pro bono work will continue to be important, but it will change in scope. The next generation of pro bono activity will extend beyond volunteer or volunteered lawyers sitting in advice centers, dispensing guidance at no cost. Lawyers who are prepared to work on a pro bono basis should be encouraged to contribute in ways that reach beyond conventional advisory service to citizens. One possibility here is for lawyers to participate in well-facilitated and orderly online discussions and to offer direct help to citizens through this medium. Another is to become active contributors to the online communities that I recommend in Section 7, should be set up for third sector workers. Yet another option is for lawyers and their firms to provide resources, standard documents, or suitably anonymized letters of advice, for example, to the banks of open-source legal materials that I predict will evolve on the web Section 4. Lawyers may indeed have a crucial role in promoting legal open sourcing. In turn, one way in which law firms may be judged in the future to be fulfilling their social responsibilities will be in relation to their contributions to online communities and resources. The support of professional bodies could be invaluable here. with a view perhaps to committing every firm in due course to providing a minimum number of contributions each year. There is a further dimension to pro bono work that needs more thought. In a multi-sourced environment, pro bono work will be one amongst many components that contribute to legal service. In practice, this might mean that lawyers or legal executives who make themselves available for pro bono work may be allocated discrete modular tasks, perhaps some research or drafting, that will be submitted by them, and then integrated as part of a multi-source service being coordinated by another. This might come about when third sector organizations invite lawyers in their pro bono capacity to undertake particular slices of work that require lawyers' skills or expertise, but for which no funds are available. 7. A healthy third sector, a vital contribution to our justice system today, is made by what is increasingly referred to as the third sector. Bodies belonging to the third sector are third in the sense that they belong neither to the public sector nor to the private sector. The term includes charities, voluntary organizations, community bodies, and social enterprises of various sorts. Generally, then, these are non-governmental, not-for-profit entities, according to the UK government, since the third sector has grown in scale and impact. There are more organizations than ever before. Overall income has increased. More people are volunteering, more people are setting up social enterprises. The sector is playing a greater role in supporting communities and tackling inequalities, in creating opportunity and enterprise, and in designing and supplying public services. To champion third sector interests across government, an Office of the Third Sector has been set up within the Cabinet Office. I'm afraid it is easy to be rather cynical about the government's support for the third sector, because this thriving sector is, arguably, undertaking tasks and delivering services that might be expected to be the province of government itself and so paid for through our taxes, rather than the responsibility of an army of admirable volunteers and, in effect, paid for out of the pockets of a few. On the other hand, charitable work and social enterprises do of themselves serve important social functions. For example, they help to promote coherence and purpose within given communities, and many third sector workers find the work satisfying and fulfilling. In any event, it is absolutely clear to me that a wide range of third sector bodies, as a matter of fact, do play a pivotal role in helping to achieve access to justice in the UK. A glance at the website of the Advice Services Alliance, ASA, the umbrella body for independent advice services in the UK, lists a formidable collection of not-for-profit organizations that offer advice and help on the law. These include Citizens Advice, Law Centers, and Shelter. ASA's main website is impressive, providing information on a wide range of legal issues in England and Wales. The government complements this on an online basis through Community Legal Advice, the website of the Community Legal Service in England and Wales. This started life in April 2 as the ambitious and award-winning website known as Just Ask. In combination, the websites and physical centers of the third sector provide citizens with a remarkable service, and to some extent in all three components, recognition, selection, and service, of my client service chain, see Section 7. On the ground, however, I understand from people who work on legal matters in the third sector that they feel badly under-resourced. Further, my impression is that the advice that is offered today focuses very largely on solving legal problems that have arisen, and there is precious little capacity for extending these services to the avoidance of legal problems, still less to the promotion of legal health. The funding of the third sector in law raises difficult policy issues. I can see on the one hand that the government must be wary of requests from the third sector in law, fearing it to be a potentially bottomless pit, and recognizing too that there is stiff competition, analogous calls on cash from, say, the worlds of health and education. On the other hand, my sense is that a modest increase in investment could greatly enhance the efforts of the third sector. Looking ahead and following the arguments in this book, I can see that a core challenge for the future of this corner of the justice system is coordination. Not simply amongst the many and various third sector bodies that provide legal guidance in person and online, but also so that the third sector's contributions can be taken as part of the multi-sourced approach to increasing access to justice. On the first point, not least in building know-how and online resources, there is always the danger of duplicating effort. Such duplication happens in relatively well-run single-site bodies, and so presents particular challenges for dispersed organizations. On the question of multi-sourcing, again the issue is that legal work should be divided and allocated in the circumstances to the most efficient potential provider. Workers in the third sector, as much as lawyers, must continually challenge themselves and check that the work they do justifies their specific skills and talents, and could not be undertaken in different ways. Once again, a wide range of technologies present themselves as possible tools for this trade. Some of these tools are disruptive in the sense discussed in Chapter 4 and threat to disintermediate the advisor, that is, remove them from the process. There is an interesting contrast here, though, between lawyers and third sector advisors. Many lawyers who make money, after all, from practicing law are unsurprisingly nervous about being disintermediated. Their livelihoods are threatened. Voluntary legal workers, on the other hand, should welcome the introduction of systems that can enhance or replace the work that they conduct manually, so they can be released to undertake more challenging or fulfilling jobs. What technologies might be relevant for the third sector? Automated document assembly, see Section 4. Is clearly one. Workers in the third sector might have considerable insight into legal issues, but not necessarily the legal experience to draft watertight legal documents or letters. If there are certain types of documents or parts of documents that are used very frequently, then with the assistance of lawyers, perhaps acting on a pro bono basis, systems could be built that could reduce time spent on drafting and increase the quality and consistency of the paperwork. Third sector workers will also benefit from the improved systems that I predict will come to be used regularly for identifying and selecting lawyers. It will surely help voluntary workers to be able to pinpoint easily lawyers who have the right experience, of whom past clients speak highly, and whose rates compare favorably, see Section 4. There is ample scope also for the use of learning systems to keep third sector workers up to date, well-briefed, and confident about legal issues, see Section 4. While some such systems might be developed specifically for them, it might also be possible to have permission to use and access systems that have been developed commercially by law firms and legal publishers. A further technique that might be welcomed is personalized alerting, see Section 4. For advisors who have special interest or involvement in particular areas of law or wish to keep abreast of a range of legal developments, web alerts and automatic updates will be invaluable. Of all possible legal technologies that might be embraced by the third sector, I believe the most exciting to be closed legal communities for advisors. I envisage a facility that could be similar in many ways to CERMO, the online community for U.S. medical practitioners. As I explain in Section 4, there are over 5 doctors now using CERMO. The system is a cross between a social networking system such as Facebook and a collaboration environment like Wikipedia. Doctors can pose questions to one another and answer queries themselves. An impressive body of medical knowledge and experience is quickly building there. At modest expense, a similar resource could be developed by and for third sector workers. They would be able to keep in regular contact with one another, share experiences and insights, build up a collective body of expertise, capture best practice, extend their fields of competence, access standard documents, retrieve useful opinions, and in so doing have more confidence in the advice they dispense and feel part of a coherent team of advisors gathered under the one virtual roof. There could also be links to legal information systems that contain further source materials, see Section 7. More, the facility could be extended to practicing lawyers, who could make themselves available to advise workers to help them with specialist legal issues. The development and implementation of an online community need not be costly, and yet its impact, alongside the other technologies I mentioned, could be profound. It is here in legal technologies that government investment in the third sector might most usefully be directed. 7. Entrepreneurial alternative providers. Even with streamlined law firms and a well-resourced third sector in place, there may also be scope for new businesses to enter the market. In England and Wales, the Legal Services Act enables, in due course, the establishment of alternative business structures for legal service organizations, and for the investment in law firms by individuals and organizations other than lawyers. It was agreed in May that analogous arrangements will be introduced in my native Scotland. In terms of the client service chain, see Section 7, like law firms, I expect alternative providers will be most active in relation to the service element rather than recognition and selection. Further, and again like law firms, the emphasis is likely to be on dispute resolution and problem-solving over dispute avoidance and legal health promotion. The untutored intuition of many lawyers and legal commentators is that so-called low-end legal service, such as consumer law and legal aid work, will not be attractive to external investors or entrepreneurs who are thinking about building new-look legal businesses. However, from my recent work as an advisor to a private equity firm, I can now see why this common view may be mistaken. In the first instance, consumer law and legal aid work together have a value in England well in excess of £1 billion. If we also take into account the likely latent legal market, depending on the elasticity of demand, this figure may be substantially larger when legal services become more easily accessible and affordable. In any event, where value is being counted in billions and the current working practices seem antiquated or inefficient, I have found a clear interest from potential investors. Where some lawyers might dismiss work as uninteresting because it is high volume and low margin, external investors may be attracted precisely because of this profile. If there is a large turnaround of routine legal activity, investors immediately see scope for more rigorous processes and the introduction of systems that can radically overhaul the conventional ways of operating. On one model, then, legal aid work would not be undertaken by myriad sole practitioners and small law firms across the land. Rather, bulk legal processing capabilities would be built, and they may not always be wholly located in England. In fact, the Legal Services Commission has already begun to encourage working practices that achieve economies of scale. As the legal market is liberated and non-lawyers are able to invest and participate in the provision of legal services, I have little doubt that the entrepreneurially minded will find new and improved ways of delivering conventional services and will create novel markets and opportunities where none had been recognized before. That most lawyers, and I for that matter, are not sufficiently imaginative to identify exactly how this might unfold in practice does not kill the idea. Indeed, it is precisely when there is an absence of such entrepreneurial insight from the legal fraternity that canny investors find great possibilities. Many lawyers are too risk-averse and immersed in practices of the past to make the leap into the next generation of legal solution providers. Just as librarians did not invent Google, lawyers may not create tomorrow's innovations in legal practice. One likelihood is the establishment of new-look legal businesses that are entirely devoted to the legal market. However, these will bear little resemblance to the pyramidic hourly billing partnerships of today. Some may bear the brand of well-regarded law firms whose operations, on acquisition, will be overhauled beyond recognition. Others will be entirely new businesses, built from scratch and driven by what is sustainable and profitable for the future rather than what has worked in the past. Another strong possibility will be the setting up of legal departments or divisions of existing consumer businesses, such as supermarkets, high street banks, and other commercial organizations that are used to dealing directly with the retail market. Both of these categories of 21st century legal service provider will no doubt design and build disruptive legal systems of the sort I discuss in Chapter 4, including, for example, document assembly and workflow systems. And they will implement these alongside other well-tested techniques, such as telephone call centers. At the same time, there will also be those who strive to attract and build human capital. Lawyers and law firms will no doubt be recruited and absorbed as part of these organizations, taken on board to undertake specialist legal work, but only when human legal expertise is genuinely required. By analogy, those supermarkets today that sell spectacles have recruited qualified optometrists to test the eyes of customers and to prescribe accordingly. But the selling of frames is undertaken in the spirit and using the techniques of the mainstream business. While many lawyers will shudder at the very prospect of being a mere cog in a consumer service machine, many citizens will find it more convenient and less forbidding to take their legal concerns to the supermarket rather than the law firm. I do appreciate that culturally, many traditional legal advisors would find it difficult to relocate to a supermarket or a bank, although some will no doubt be attracted by more flexible working arrangements. But it will be a very different working environment. I expect that professional and regulatory bodies around the world will, in any event, soften the blow somewhat, by requiring that lawyers who come to work in retail and other environments will still be governed and supported by well-established professional rules and values. These will include regulations that determine whether specific retail outfits are indeed fit to own and run legal businesses. A further dimension to this scenario that is threatening for conventional law firms is that we may find some retail organizations, banks, or building societies, for example, that will offer legal services not to profit from these directly, but as a way of building other businesses or enhancing their brands. The result here would be a service that might undercut that of traditional lawyers, both because more efficient processes and systems are used, and also because there will be no profit margin built into their pricing. It is hard to compete with businesses that are not trying to make money. 7. Accessible legal information systems. I come now to the question of access to the law itself. For lawyers and advice workers at least, ready access to primary legal sources, legislation and case law, and to various secondary sources, commentaries, texts, and analysis is fundamental. These are basic tools of the trade of lawyering. We cannot have access to justice if our lawyers and legal advisors do not have access to the law. Today, it might seem blindingly obvious that primary sources should be freely available on the web, but this was a matter of great contention in the mid to late 1990s, and the story surrounding the debate of the time is worth relating. My focus here, incidentally, is very largely on legislation. Traditionally, which for current purposes can be taken to mean before the web, to gain sight of statutory material, a reader had to visit a library or purchase a hard copy of the instrument in question, or perhaps buy a textbook in which the law in question had been reproduced by permission of the Crown. This state of affairs attracted all sorts of criticisms. It was frequently asked, how can citizens be presumed to know all of the law if its contents are not accessible? And when the web came along, why is statutory material not available on the information superhighway, as it was then called? I ranted about this at some length in The Future of Law, railing both against the way legislation was published electronically. It was perceived at the time that the government was seeking to make a profit from selling the law, and in opposition to the way in which the law was promulgated, or more accurately, not being promulgated. This term refers to the mechanism for letting the public know when a new law is enacted. I went as far as to say that the state was failing to legislate meaningfully. These were heady days. But I had to qualify my words almost immediately. At proof stage, I inserted a footnote that ran as follows. As this book went to press, however, the government announced on 9 February 1996 what appears to be a sensible change in policy in relation to the electronic reproduction of legislation, although it is too early to know what the practical effects might be. The gist of this ministerial statement seemed to be that the government would be permitting the free republication of statutory material on the internet. Nonetheless, progress was slow, and an active and articulate group of lawyers and legal technologists ran a campaign under the banner, Free the Law. Their aim was to bring about the free availability of legislation and case law on the internet. They pointed to the formidable Australian system, AustLIA, the Australasian Legal Information Institute, in support of their claim that it was both possible and desirable for a modern jurisdiction to have all of its primary source materials online. The applicability of the AustLIA approach to England became the focal point of what transpired to be a seminal meeting, itself entitled Free the Law, held at Chatham House in London on November 1. Professor Graham Greenleaf, one of the original developers of AustLIA, enthused the assembled audience and helped to galvanize the community in question into further action. I had the good fortune to chair the debate that followed, although I was far less involved in the initiative than Laurie Westknights, now QC, and Lord Justice Brooke, who were great champions of the cause and spoke so compellingly that evening. As a direct result of that meeting, a pilot website offering free access to an integrated body of British and Irish legislation and case law was launched in March 2. Christened BAILA, British and Irish Legal Information Institute, the pilot held 7 searchable documents taken from the 5 jurisdictions and was bound together by million hyperlinks. The system was developed with the assistance, along with the software and the methods, of AustLIA. Just 8 years later, we now take so many online resources for granted. But at the time, 2 features of the BAILI were remarkable, groundbreaking, and even breathtaking for the legal communities of Britain and Ireland. The first was the sheer quantity of materials. To have such a rich body of legislation and case law at the fingertips of internet users at no cost to them was invaluable and almost unbelievable. Second was the usability of the service. Many of the documents were connected to one another by hyperlinks, enabling users to jump, for example, from law reports that referred to legislation into the specific sections being cited. This ability to browse around and between the materials was perhaps the cleverest aspect of the AustLIA toolkit. When documents are loaded into the system, the software automatically detects citations and references and then inserts the links between materials. A huge network is created, but manual intervention is minimal. Today, BAILI is thriving. Run as a modestly funded charity, it provides the largest free-of-charge online collection of British and Irish primary legal materials, legislation, and case law. The service now contains approximately 76 databases, covering 7 jurisdictions and holding 2 searchable documents with about 15 million internal hypertext links. BAILI continues to use the Australian technology, as contributed originally by AustLIA. The databases on BAILI are drawn from a variety of sources. Some are taken from existing websites, others are from databases that are on published and unpublished CD-ROMs, and still others are direct or indirect feeds from relevant courts, government bodies, and other organizations. All of the data is converted into a consistent format, and a set of search and hypertext facilities are added. While BAILI has flourished, the government has been far from idle. For example, vast quantities of UK legislation, primary and secondary, are now made available online at no cost to users. This is now a key public service provided by Her Majesty's Stationery Office (HMSO) through the much-used website of the Office of Public Sector Information (OPSI). Amongst other materials, the site provides the full text of all UK Parliament Public General Acts from onwards, of all UK Local Acts from onwards, and all published statutory instruments from onwards. Usefully, these are available in HTML and PDF formats. HMSO aims to publish these documents on the OPSI website simultaneously, or least within 24 hours of their publication in printed form. At the same time, bills that are current before the UK Parliament are also available online, at the website of the UK Parliament. In practice and in terms of policy, the progress that has been made since the mid-1990s in freeing the law has been staggering. However, it would be wrong to assume that we now live in some legislative utopia, and that access to justice has been secured by putting statutory material online. Daniel Greenberg, Parliamentary Counsel, a legislative draftsman of considerable experience, expresses the current position in the following terms. For most practical purposes, the access afforded by Queen's printers' copies or the OPSI website is utterly useless. This is because of the fact that an enormous amount of new legislation, both primary and subordinate, operates by referential amendment of old legislation. The result is that the text of an act as passed 10 years ago is of no help at all in telling me the state of the law now. Every time I access an act or an instrument which amends an earlier one, I am forced also to obtain the text of the earlier one, and to construct a revised version reflecting what will often turn out to be a complicated multi-layered set of amendments. Difficult and time-consuming, but arguably not impossible. More problematically, however, I will have no practicable way of knowing that the act or instrument I am reading has not itself now been amended by a later one. If an experienced legislative draftsman finds it challenging to use the HMSO OPSI website to find what law is in force at any given moment, what hope can there be for the citizen? Having all published legislation available in electronic form is a wonderful facility, but it is a first step rather than the last word in providing access to justice. Non-lawyers could not hope to determine their legal rights and obligations simply by browsing through archives of legislation. Interestingly, the government is working towards a more powerful tool that would meet Daniel Greenberg's concerns. It has developed and delivered the UK Statute Law Database (SLD). And when it launched the service in December 2, the Department for Constitutional Affairs, now the Ministry of Justice, expressly said that this database was a contribution to the department's aim of improving access to justice. I first heard that the SLD was in the pipeline in June 1. Lord Mackay of Krashen, then the Lord Chancellor, told me about the project when we met at a conference in Oxford. He was rightly enthused. I was too. Now I concede that you should not rush into major IT projects in the law, but 15 years for completion was deeply disturbing. The development of the SLD seemed to be fettered by an unholy and endless series of delays and problems. And between conception and birth, a great deal happened. For instance, the web was invented, BAILI was introduced, and HMSO transitioned from selling printed legislation at a profit to providing a powerful database of legislation at no charge for internet users. Nonetheless, SLD has brought features that neither BAILI nor HMSO offer, and goes some considerable way to meeting Daniel Greenberg's objections. Impressively, and again at no charge, users can view amended legislation as it has changed over time. Examine the way in which legislation will be affected by amendments that are not yet in force. See how legislation has been changed for different jurisdictions, say Scotland as compared with England and Wales, and browse across links between affecting and affected legislation. A key feature of the system is that it can offer a historical view of the legislation that was in force on any specific day. There is one wrinkle, however, and it is not trivial. The SLD is not yet up to date. When launched, the database held over 3 items of primary legislation that were in force at February and primary and secondary legislation that has been produced since then. Today, according to the SLD website, the service carries most, but not all types of primary and secondary legislation. Most primary legislation is held in revised form, but most secondary legislation is not revised, and all legislation that is in revised form has been updated at least to the end of 2. The truth is, it is not quite finished, although what is there is very promising. Until the SLD is up to date, for both primary legislation and for statutory instruments, and the latter, as Daniel Greenberg points out, account for an increasingly important part of the practical legal burdens on the citizen. And until this is integrated with a similarly up-to-date body of case law, perhaps in the manner of BAL, those who want to undertake up-to-date research still have to rely on the publications and online services of various commercial providers. While these services are powerful and comprehensive and may be affordable for those who are in the business of law, their subscription fees are beyond the pockets of most citizens. Before I talk about the implications of this current state of affairs, I feel impelled to throw down a gauntlet for those who aspire to developing the next generation of legal information systems. I would like to see the evolution of a Wikipedia-like service covering the UK legal systems. This online resource could be established and maintained collectively by the legal profession, by practitioners, judges, academics, and voluntary workers. If current leaders in the UK legal world are serious about promoting our jurisdictions as world-class, here is a genuine opportunity to pioneer, to excel, to provide a wonderful social service, and to leave a substantial legacy. The initiative would evolve a corpus of UK law like no other, a resource readily available to lawyers and lay people, a free web of interlinked materials packed with scholarly analysis and commentary supplemented by useful guidance and procedure, rendered intensely practical by the addition of action points and standard documents, and underpinned by direct access to legislation and case law made available by the government, perhaps through BAL. And we should not stop at text. We should add video and audio clips as well, perhaps of seminal lectures of the day or even of our senior judges delivering judgments. How marvelous would it be if we could watch and listen to, say, Lord Atkin read his judgment in Donoghue v. Stevenson. A Wikipedia of UK law could be an evolving, interactive, multimedia legal resource of unprecedented scale and utility. Let me turn back now to the problem of the day, that we do not have an easily accessible, authoritative, no-charge, comprehensive, fully up-to-date and maintained legal information system. I do see this as a cause for concern, and I know that many commentators believe this lack of free access to all law in force as an outrage. But I think, in relation to citizens, there is a far larger worry that should exercise us more. I have no doubt that lawyers and legal advice workers, alongside law students, legal academics, many professional service providers and public sector workers, need easy access to primary sources of law legislation and case law. And I can see that the readier is this access, then the greater is the likelihood of improving the quality and reducing the cost of services provided to citizens. In other words, accessible legal information systems that hold primary sources will directly benefit lawyers and those who work with the law, but will only indirectly benefit the citizen. I simply cannot see and never have seen the attraction or the wisdom of citizens plowing their way through, say, a 50-page statutory instrument. Even if he or she had ready access to such a document, the average citizen would A. be bored senseless reading it, and B. not be sufficiently familiar with the legal jargon and the broader legal context to figure out its full implications. If one of my children has a disease of some sort, I do not want to read some paper in medical speak about the epidemiology or the pathology of the disorder. I want to know what to do, I want advice, I want to take practical steps. If I have a problem with my computer, I do not wish to subject myself to some learned treatise on the shortcomings or idiosyncrasies of the underlying programming language. I want it fixed. I want it not to happen again. I want to be told what to do next, so too in law. As I have said for years, citizens have little interest in the canons of statutory interpretation or in determining the ratio decidendi of binding precedents. Instead, they want quick, cheap, punchy, practical, and jargon-free guidance. Citizens who have legal issues also want to be told what to do. This, for me, helps us to define the next generation of legal information systems for citizens as opposed to those for law workers. The challenge of having accessible legal information systems in place will not be met when SLD is up to date and integrated with a similar system for case law. No. This battle will only have been won when citizens can go online, and through a second generation of legal information system, secure digestible and actionable guidance that helps them in their own precise circumstances. Databases of statutes and cases will not do this job for citizens. Instead, we will need different tools, ones that actually give help rather than point to potentially relevant legal sources. Some of these are identified in chapter and are discussed in Section 7. Automatic document assembly, online legal services, legal open sourcing, and online communities. Simpler aids will also be effective. Decision trees, flowcharts, and FAQs, frequently asked questions, for example. In the broader context of my analysis of the access to justice, in Section 7, These second-generation legal information systems should help not just in solving legal problems, but in avoiding problems, and even also in promoting the legal health of users. However, in relation to my client service chain, also in Section 7, these systems will tend to contribute much more to the service element, providing affordable and accessible help, than to the selection and recognition elements. They will be less useful, that is, in helping citizens to select the best source of guidance, and to recognize the optimum point at which they would benefit from legal guidance. If legal information systems are of comparatively little help to citizens in helping them recognize if and when they need legal guidance, does this then scupper any hopes that it can crack the problem of promulgation? This problem, to recap, is that we do not have systematic and effective techniques for bringing to citizens' attention when there are new developments in the law or changes in old law. As many commentators and scholars have pointed out, it is bizarre at best that citizens are presumed to know the content of the law, and yet the state takes no responsibility for actually informing the general public about new or changed law. Jeremy Bentham, the great 19th century legal theorist and social reformer, put it more forcefully when he said that the notoriety of every law ought to be as extensive as its binding force. It ought indeed to be much more extensive. No axiom could be more self-evident, none more important, none more universally disregarded. Some legal philosophers have gone further and argued that laws that are not promulgated are not laws at all. Even if we stop short of this position, it is hard to see how genuine access to justice can be achieved without effective promulgation. Contrast today with the past. In years gone by, all acts of the Scottish Parliament, the previous one, were published at the Market Cross of Edinburgh, while sheriffs in England were once required to proclaim all new statutes throughout their bailiwicks. The people of the land could scrutinize the law when it came down from on high. Today, however, new laws come into force and old laws are repealed, and no one has any clue what is going on. Even lawyers. Part of the problem here is that we are suffering from hyperregulation, the term I use to bemoan the reality that we are all governed today by rules and laws that are so complex and so extensive that no one can pretend to have mastery of them all. Recent research by the legal information providers Swein and Maxwell suggested that 3 new laws were introduced as compared with 2 in 2006. We are running, therefore, at about 8 new laws every day. Who on earth could hope to cope with that influx? Yet in larger part, the problem of promulgation is about defects in communication. As the statute book and common law have grown, we have not had workable channels through which to keep people up to date with new and changing law. However, I can see a new type of service emerging that might just provide the mechanisms we need to overcome this age-old shortcoming in modern justice systems. I am thinking here of personalized alerting. As I explain in Section 4, this is an internet-based technique for delivering legal updates, briefings, and alerts automatically and proactively to the desktops of citizens. Whether supported by the government or delivered by some intermediary, this would allow citizens to register topics in which they are interested, supplemented perhaps by profiles of their interests that could be derived automatically from their clickstreams and online movements, and they would be notified of every new regulation, every rule, and every judgment that affects them directly, or impacts on members of online communities of which they are members. If supplemented by the gloss that Web 2 methods can provide blogs, personal commentaries, guidance through discussion forums, all built up in wiki-like manner, then we can begin to imagine a world where citizens are informed in a digestible way when there is a new law that directly affects them. This can be anyone from a chiropractor to a carpenter, from a brain surgeon to a tree surgeon. In the future, on the strength of such techniques, we may come to regard as entirely antiquated the notion that the lawmaking process ends with the published articulation of legal provisions. An indispensable component of lawmaking will be that of bringing new law to the attention of the people. 7. Enlighten public information policy. If we are serious about radically increasing access to justice, I believe there is a broader challenge than making legislation, case law, and other quasi-legal resources available through online legal information systems. I am thinking here about the role and responsibility of public bodies in promoting understanding of legal and regulatory issues. The rules and laws that govern us all are invariably originated, administered, or enforced by public bodies in central government, local government, and beyond. In total, in the UK, there are over 1 public bodies. Although most are intimately involved with the law, very few regard it as part of their public task to raise public awareness of legal matters, to educate on or clarify issues of law, or to alert citizens to legal developments that might affect them. This is a huge opportunity missed. Enlightened public information policy would encourage or even require public bodies to take on the job of drawing attention to the laws, regulations, and rules that are so central to their daily work, and ensuring they are made more accessible and digestible to the citizenry. To grasp the scale of the challenge here requires my final detour of the book, this time into the fairly arcane world of public information policy. Governments and public bodies have, of course, always been in the business of managing information, as creators, controllers, distributors, and more. Looking back, though, as a holder of information, until a decade ago, the state really had only two main roles in relation to information. First, there was the responsibility to ensure that information on matters of national security was held securely and beyond the reach of potential miscreants. Second, there was the job of ensuring that full records of public affairs were maintained, archived, and accessible to authorized persons. Over the past decade, there has been a clear shift in UK government policy in relation to information generated from within or on behalf of the public sector. In summary, the UK government has shown a commitment to making official information more easily accessible. There are two main strands of thinking here. One is that government should be more open. This has given rise to the Freedom of Information (FOI) regime. This is about providing access to information. The other strand is that public sector information can and should be reused where benefits can accrue. FOI and reuse together are the fundamental building blocks of what many call information age government. This is not merely about making formal government publications available online. It is about capturing, nurturing, and maintaining much of the information generated by public sector bodies as a common and easily accessible good for all of society. At a policy level, these developments will combine to bring about an entirely new landscape for the management and control of information in the public sector. It is far from clear, however, that most senior officials and politicians are yet alive to the cumulative shift in policy and practice, nor is there evidence of analysis of the long-term implications of these changes. That said, the last decade has undeniably witnessed enormous change, to a large extent catalyzed by the advent of the internet, which is steadily, fundamentally, and globally changing the relationship between the individual and the state. Before the 1990s, most government was closed government. Official information was made available largely on a need-to-know basis. Restricting the flow of information was clearly central to totalitarian rule, for example, but benevolent democracies also held back, adopting a paternalist posture, releasing information sparingly. Perhaps it was not in people's interests to know too much. Anti-paternalists claim the problem was rather that there were no effective channels for fuller information flows between citizen and government. But this changed in the 1990s with the coming of the internet. Suddenly, information could be shared widely and cheaply, and in and one, the conservative and Labour governments stated their commitment to providing official information on the web. Why? Was it that the internet made it all but impossible for government to resist greater openness? Or was there, coincidentally, some new political will to make public affairs more transparent? Either way, open government arrived. I argue that there are two types of open government. A reactive open government, when faced with a request for access to official information, will respond favorably. Request leads to access. In contrast, a proactive open government believes that an integral part of the job is to make all information created in the process of governing available to the people. Proactive open government is much more than meeting, more or less willingly, a request for access. Instead, it is regarding the provision, usually online, of all official information as part of the very business of government. Withholding information is looked upon as exceptional and requiring justification. The UK government is currently moving from being reactively to proactively open. One sign of this is the drive to provide more useful and better stocked websites. Another is that, under freedom of information legislation, all public authorities must maintain publication schemes which indicate what information will be made available proactively. However, full-scale proactivity will require a positive effort on the part of public authorities actually to maximize the value of their information, not just in terms of financial return but in terms also of social utility. A vital step in this direction was the adoption, at the end of the EU Directive on the Reuse of Public Sector Information. After extensive consultation, the government decided to implement this directive through the Reuse of Public Sector Information Regulations 2, which came into force on July 2. It was also decided that there was a need for a dedicated body to be the principal focal point for advising on and regulating the operation of public sector information reuse. The Office of Public Sector Information was established for that purpose, a body that is itself assisted by the Advisory Panel on Public Sector Information, APPSI, of which I was chair from until 2. The panel is a non-departmental public body, established by the Cabinet Office in April and now attached to the Ministry of Justice. Informally, its strapline is Realizing the Value of Public Sector Information. This intentionally trades on two different meanings of realizing. The panel's focus is on identifying, articulating, and raising awareness of the value of PSI as well as on encouraging its exploitation. APPSI has found in relation to the reuse of PSI that there are two broad challenges. The first is to ensure that core public sector information is made available under appropriate conditions to intermediaries who can add value to it. The second challenge is more radical. It is about information management and knowledge management on a grand scale. It is about making sure that the valuable collective knowledge and experience, the intellectual capital of public sector workers, is captured and reused. Today it is barely managed and is underexploited. In a sense, knowledge has become disposable. I submit that systematic recycling is instead required. There are vital lessons here for those who are committed to promoting greater access to justice. Swirling around our public sector, substantially unmanaged, are legal resources and other data that could be invaluable for intermediaries, academics, charities, businesses, and others who are trying to repurpose this raw material and develop systems that provide legal information and guidance. There seem to be no limits to the ingenuity of people who work with the web. My strong intuition from years in the field, and this is the first lesson, is that if we make legal and regulatory information readily available and easily accessible, then exciting developments will follow. BALI is one clear illustration of this. BALI indeed is an early and fine example of the reuse of PSI. The raw material in the form of statutes and law reports was brought together and subjected to remarkable technology that was developed by Australian academics. A new, extremely valuable information resource was thereby created and is now available to all. More than this, where BALI has been of immense significance, the service has actually brought about a shift in the government's approach to statutory material and law reports, a shift from being reactive to being proactive. Source materials for inclusion in BALI, whether legislation or law reports, are now provided as a matter of course. It is part of the process of government of the Ministry of Justice and OPSI. BALI is not just about making legal information available to lawyers and citizens, which in itself is of great note. More than this, it is a very early example of a fundamental shift in the nature of government, a shift towards thoroughgoing proactivity. In the spirit of BALI, and following the discussion of the previous section, I can easily imagine a wide range of wiki-like open-source services sprouting across the web, each underpinned by the core legal data that have been released and organized not according to the traditional categories of the legal textbook, but built around the life events of citizens: job loss, house moving, borrowing money, setting up pensions, divorce, and so forth. The second lesson we can learn from experience in the world of PSI relates to knowledge management, and the opportunity here may be even greater. In their everyday work, public sector workers deal with legal and regulatory matters all the time. In so doing, invaluable insight, analysis, and research are produced. If we could capture just a fraction of this collective knowledge and make it available to citizens in a digestible form, then we might contribute immensely to the promotion of access to justice. In terms of my client service chain, see Section 7, I can see that this knowledge, if made available via the web, could be of particular help to citizens in helping them to recognize that they need or would benefit from legal guidance, and in sorting out their own legal challenges on an online self-service basis. Gathering and providing this public sector knowledge would be a huge step towards proactive open government, but it would require a seismic shift in culture in the public sector workplace. Officials and civil servants, amongst many others, would now be asked to view their work in a new way. Beyond the discharge of their daily work in the normal manner, we would be asking them, as a byproduct of this work, to identify, capture, and nurture knowledge that they think could be of use to the citizen. I am not sure whether this is too much to ask. I am suggesting that it should be incumbent on all public bodies to promote greater understanding of the legal and regulatory issues with which they deal, to explain and shed light on complex issues, and vitally, to strive to alert citizens to developments in the law that might be relevant for them. Legal knowledge and experience, as generated in the course of public work, should not be secreted and locked in heads, filing cabinets, or databases. Instead, it should be shared with taxpayers, with the citizens in whose interests the law is created in the first place. The purpose of this sharing is not simply to give citizens sight of more documents. Rather, in the spirit of Web 2, it is to make public information available as a raw material that citizens, entrepreneurs, charitable bodies, and many others can fashion, reorganize, and supplement for their own purposes. Public bodies will be providing the raw information upon which communities of interest and citizen-generated content will be built.